Thank you, my lords. I will go straight to the issue that I was invited to address. And my submissions are targeted at responding to paragraph 92 to paragraph 105 of the petition. In that paragraph 92, this is the allegation made against the third respondent and for which I'm responding. It is said that the petitioners affirm that the election was not conducted by the first and second respondents independently, nor was it administered in an impartial and neutral manner. Insofar as administrative decisions by the first and second respondents were directed and made at the behest of the third respondent and his political party. My Lord, the heading of those paragraphs is the lack of independence, impartiality, and neutrality of IEBC. Now, my Lords, 4 issues have been raised in support of that allegation that there was impartiality. The 4 of them are these. The first one is that the chair of the electoral body changed the dates for elections, and that is attributed to the third respondent. The second one is in terms of the consultations held between the minister in charge of education for purposes of scheduling the date for elections so as not to coincide with the dates for school exams. The third issue, my Lord, was the fact of the declaration of a national holiday on the 28th of August by the Cabinet Secretary. The fourth one and the fifth one are issues related to the internal affairs of the electoral body, being particularly alleged issues as between the commissioners and as to the staff work assignments and duties, and issues of legal opinions and court cases, which, according to the allegations, were lost by IEBC. Now, my lords and your ladyships, all those allegations can be divided into 2. The first one relates to the activities of the cabinet secretaries in charge of education and in charge of security, which coincidentally was one person, and the other one relates to the allegations advanced by a commissioner, one Dr. Akombe. In terms of the actions of the cabinet secretary, being the declaration of the holidays and the consultations for purposes of agreeing on a convenient date, we submit, my lords, that first of all, the decisions and the actions of the cabinet secretary belong to him and cannot be attributed to the third respondent. The second one is that in the absence of a contest, in absence of a direct challenge on his actions must be assumed to have been done in good faith. On the part of the allegations in relation to Dr. Akombe's letters and postulations, my lords, we submit, first of all, that in attempt to give credibility to the allegations by Dr. Akombe, it was said that the chairman had confirmed those allegations. My lords, we submit that considering the fact that the chairman has sworn an affidavit and has confirmed himself that as far as he's concerned, the elections were credible, that they were transparent and accountable and auditable, my lords, we submit that in fact Akombe's allegations have no support. Secondly, my lords, we submit that what that commissioner said were matters of our own opinion, were matters of our own speculation, were matters of our own conjecture in terms of how the commissioners were relating with each other and how the staff assignments were being made in the electoral body. My lords, I wish to make reference to the provisions, to the decision made. We have appealed to the court in our submissions at paragraph 35, at paragraph 43, we have appealed in our submissions. We have quoted a decision made by this honorable court, advisory opinion number 2 of 2011, in the matter of the interim independent electoral commission 2011. And it is our submission that the consultations that the chair may have had, both the chair and the electoral commission may have had, were within reason and are legitimate and lawful. And the court, in its opinion, in that opinion, advisory opinion number 2, said that issues that independence does not mean detachment, it doesn't mean isolation, and it doesn't mean disengagement. And with your permission, I'll just read a very short excerpt of that decision. The court said this: independence clause does not accord a carte blanche or act or conduct themselves on whim. Their independence is, by design, configured to the execution of their mandate and performance of their functions as prescribed in the Constitution. For due operation in the matrix, independence does not mean detachment, isolation, disengagement from other players in the public governance. Indeed, for practical purposes, an independent commission will always find it necessary to coordinate and harmonize its activities with those of other institutions of government or other commissions, so as to maximize its results in the public interest. Constant consultations and coordination with other organs of government and with civil society, as may be necessary, will ensure seamless and efficient, effective rendering of services. We submit and rely on that. And the last sentence made by that court again saying, public governance tasks are apt to be severely constrained by possible clashes of independence if independence is overstated and overemphasized. My lords, lastly, may I rely on a decision that was provided by the respondents, by the petitioners themselves, and that is attached to their submissions at page at page 19 of their, sorry, not page 19, page 16 of their decisions, of their submissions, my lord. And in that case, being a decision made in South Africa, the criteria given for determining whether or not, sorry, it's actually Communication Commission of Kenya versus Royal Media Services. It is reported as 2014 EKLR. And the issues that the court would have to look at is whether either government or political interest or commercial interest were such that orders were issued to the independent body or instructions or intrusions. Probably in that decision, what was left out is NGOs and activists. And my lord, we submit that having listed the 5 allegations that constitute the argument as to lack of independence, we submit that in fact, they do not amount to the orders contemplated by that decision, nor instructions, nor intrusions, but are actually reasonable, legitimate interactions. Lastly, my lords, I know I said lastly, this is the lastly I'm saying.
I'm happy you've answered yourself.
Yes. My lords, I rely on Article 81 and Article 249 of the Constitution. The two constitutions require 81E subparagraph 2, require that the election should be free of violence, intimidation, and corruption. I also rely in relation to that the Election Offences Act. And my lord, I submit that that call on the IEBC at Article 81 in itself contemplates a cooperation between IEBC and the Director of Public Prosecution, and a cooperation between IEBC and the Anti-Corruption Commission to the extent to which it expects elections to be free of violence, intimidation, and corruption. Article 249 requires that Parliament should facilitate adequate budget for purposes of carrying out functions. And we submit, my lords, that it suggests 2 things. That first of all, the IEBC is to transact with Parliament and with the Treasury. And when it says, in the words of Article 249, adequate funds, we read into that the likelihood of a requirement or expectation that there would be consultations, my lord. And we submit, therefore, that the fact that IEBC was constrained to have to consult so as to make sure that the elections were seamless and were free from violence do not constitute a basis to contend that there was interference with the election and the electoral body. Thank you very much, my lords. I really appreciate that you gave me this time. Thank you.
Thank you, Mr. Keegan. You were perhaps forgotten because you sat at the back.